courts of appeals. Professor Corcoran served as lead counsel in two of the most significant civil rights victories before the Supreme Court during the 2020 term, Torres v. Madrid and Taylor v. Riojas. Earlier this year, Kelsey was counsel for Deborah Lawfer in Lawfer v. Atchison Hotels, where the court considered civil rights tester standing. And that case counts as something of a victory for the civil rights bar, simply because the court did not issue a decision on the merits there, finding that the case was moot. In this past April, Kelsey argued the case we're discussing today, Johnson v. Grants Pass. Our conversation will go for about 30 minutes or so, and we've reserved another 15 minutes after that for any audience questions, some of which I've already received. So if you have those, just go ahead and put those in, and I will select those at the end. So I'll start just with a quick summary. The decision has as its backdrop the relatively small town of Grants Pass, Oregon. And Grants Pass is home to about 38,000 people, approximately 600 of whom are unhoused on any given day. Like many cities, Grants Pass has passed a series of laws to address its homelessness problem. The question at issue in this case concerns how far cities can go to prohibit unhoused individuals from living and sleeping in public places. Can the government prosecute you for sleeping in a park with a blanket? That's sort of at its core the question. The Ninth Circuit Court of Appeals held that the Eighth Amendment prohibition on cruel and unusual punishment places limits on these types of restrictions. The Supreme Court disagreed. The court held that the Constitution, at least the Eighth Amendment, has nothing really to say about these so-called anti-camping laws. Cities, therefore, are free to criminalize sleeping in public if the reason you're sleeping in public is that you're unhoused. So just to start off with our first question, Kelsey, can you talk a bit about the origins of the case, your clients, and about how this issue wound up in the Supreme Court?
Yes, thanks, Ryan. And thanks for having me. I'm glad to be here with you all. So I'll just say at the outset when I'm describing the record in the case, I am going to be tying everything I say to the actual factual record to distinguish from some of the things that have been said on the other side. And it's going to be the summary judgment record that was developed when this case was before the district court. So I'm talking about Grants Pass at that time. But as you alluded to, Ryan, Grants Pass had a significant housing shortage, like many West Coast cities, bankruptcy rate of 1%, no affordable housing. And as a result, 600 Grants Pass residents became homeless. If you look in the record, most of them lived in Grants Pass for a long time, had homes, jobs, and then cancer or some other sort of disability or job loss led to them losing their homes. There are no homeless shelters in Grants Pass. There's one privately run religious transitional housing program that doesn't take people with disabilities and requires residents to work full time, and it can only serve a fraction of the population. So as a result, you had hundreds of homeless residents who had nowhere to sleep but outside. The Grants Pass City Council decided that a way that it was going to deal with this vagrancy problem was to push all of its homeless residents into neighboring jurisdictions. Initially, the police tried to buy bus tickets to send folks away, but they'd end up coming back to Grants Pass with a request from the other location not to send them there. So the city decided instead it would make it so uncomfortable in the city that the homeless people would leave on their own. And so they decided they would aggressively enforce a set of ordinances that were designed to make it impossible for the city's homeless residents to remain in Grants Pass without facing criminal punishment. So you'll hear the word camping a lot when Grants Pass talks about these ordinances. What the ordinances actually restrict goes far beyond any ordinary meaning of that word. Camping is using a blanket for the purposes of maintaining a temporary place to live. So it's nothing to do with tents or other structures. It's having a blanket, sleeping with a blanket, and the language for the purpose of maintaining a temporary place to live was designed to limit the ordinance's application to homeless people. So if I sit in a park in Grants Pass with a blanket around me, I'm not violating the statute because I'm not sitting up a temporary place to live. I have a home. But if I don't have a home and I do that, I have now camped in Grants Pass and I'm subject to a cascade of fines and jail time. So the city decided it was going to aggressively enforce these ordinances. The police went around and told all of the homeless residents that they could no longer lawfully be in Grants Pass and they need to leave. Those who did not have a car were told to go to federal wilderness outside of the city limits, a place called Devil's Slide. The city affirmatively argued below that it should be allowed to force its homeless residents out into the woods. So I give some detail there because it's missing from the majority opinion in this case, and I think it's important to understand what was actually going on. Three plaintiffs brought suit in a class action, all homeless residents of Grants Pass. They were able to get an injunction. We'll talk, I think, in a minute about the substance of the underlying constitutional law. But I want to be very clear before we move on to the law, just on the facts. The injunction here did not prevent the city from imposing time, place, or manner restrictions on when homeless people can sleep. They were free to say, you can sleep only in this park at this time. It allowed the city to ban tents. It allowed the city to clear encampments. It allowed the city to enforce the sleeping ban against homeless people who decline shelter. And it allowed the city to fully enforce all of its laws regarding littering, public urination, defecation, drug use, violent behavior. Truly, the only thing the city was not allowed to do was impose a 24/7 citywide sleeping ban that forced the homeless residents to move or face endless fines and jail time. The Ninth Circuit affirmed that injunction, and we went to the Supreme Court.
Thanks, Kelsey. That's really helpful framing for those of us who are not steeped in the facts as you are. Because when you pick up Justice Gorsuch's majority opinion, one thing that I found striking is that it doesn't start with any of those facts that you're talking about. The first several pages read like a policy briefing. Usually courts don't lead with policy arguments, but here they hit you immediately. There's a lot of discussion about, as you said, homeless encampments as a health and safety hazard, a parade of horribles that includes typhus, gunshots, and drug needles. There's a lot of discussion about how cities are paralyzed by an inability to deal with encampments, a long footnote about all the cities that have signed on to amicus briefs supporting Grants Pass. I'm wondering, did you find that lead in surprising when you read it? And what do you think the court was up to by opening that way?
Yeah, I have a lot of thoughts, so I'm going to filter myself a little bit. I think, not to jump ahead, but the Supreme Court ended up upholding the city's ordinances. It could have done that by being honest and confronting the actual record here and saying, yes, we think it's fine to criminalize the homelessness, at least as a matter of the Eighth Amendment. And instead, you see this narrative that not only distorts the facts for the reasons I just said, and also you'll see in Justice Sotomayor's dissent, but it's talking about a whole slew of things that actually have nothing to do with this case. And I think, when you start talking about drug addiction and mental illness and defecation outside and typhoid and all these things, I think the two things are happening. You're trying to kind of dehumanize the group of people that are at stake here, and then also kind of deflect, right? Homelessness policy is a really complicated question, right? What do we do when we have so many people who truly have no place else to go in terms of encampments, right? There's a lot that even people within the homelessness advocacy community are struggling with. This case does not involve any of that. At no point was there any assertion here by the plaintiffs or the lower courts that the Eighth Amendment constrains the city's authority to outlaw sleeping in the streets or to clear encampments, let alone dangerous, like fire-prone encampments. It's just not what this case is about. And that's because we needed to keep our claim incredibly narrow to stay within the court's precedent on the Eighth Amendment, which we will talk about in a minute. So it's a lot of deflection from what was actually stake. And I will say, encampments, I know, are very controversial on the West Coast. The extent to which authorities can clear encampments is a Fourth Amendment issue. It has to do with unreasonable searches and seizures. It is not an Eighth Amendment issue. And so it was outside the scope of this case. So really, it was disappointing. The actual policy question here is whether localities have authority to, exercising their state police power to banish a group of people from the community and push them into other jurisdictions, right? This is the idea of closing the city gates and saying we don't want this usually it's happened, over the course of history, particularly with impoverished groups. We don't want them here, so we're going to push them into a neighboring town. That's a big policy question because we have 652,000 homeless people in our country, and if every jurisdiction can just pass laws making it uncomfortable enough that they move elsewhere, we end up with a patchwork of local laws that leave 652,000 people with literally nowhere to go. So I think if we were going to start it with policy, that would be the one to start with.
Do you have a view on what the policy answer is to those sorts of questions and also to the sorts of questions that the majority opinion is raising?
Um, you know, so it's hard to answer that because there are so many kind of different things they're raising. Right. I think encampments, what folks in the homelessness advocacy community would say is we need more housing, right? There's overwhelming evidence that the root cause of homelessness in our country is a severe housing shortage. There are only 34 affordable housing units for every 100 low-income families. So there's no amount of kind of incentivizing or trying to make people do better that's going to make housing materialize for the other 66 families. It just doesn't exist. So as a matter of basic math, we're going to have hundreds of thousands of people living in public with nowhere to go. That's not a constitutional question, right? We weren't arguing for an affirmative right to housing. That's a policy question that will be decided in the legislatures. This case wasn't intended to solve the problems of homelessness. It was a stopgap to kind of whatever you're going to do localities, whether it's providing housing, providing mental health services, providing other sorts of social services, whatever you're going to do, you can't just criminalize the existence of homeless people in communities. You're going to have to confront that problem and figure out a way to address it in a way that doesn't violate people's constitutional rights. So it almost goes beyond like kind of the question of what the policy answers are. You have every other tool in the toolbox to address the problem. It's a hard problem to solve. You just can't criminalize the existence of the people who are part of your community and have nowhere else to go.
Right, absolutely. And I'd like to talk a little bit about the legal tools that you used in this case. From a legal standpoint, this case is all about the scope of the Eighth Amendment's cruel and unusual punishment clause. And I have to admit that when I first learned of this case, I was surprised that that was the legal theory. That was my ignorance, I guess, to not understanding that Eighth Amendment could apply to this sort of context. But as the majority does state, the cruel and unusual punishments clause is typically about what happens after a criminal conviction, not whether a particular type of conduct can be criminalized in the first place. And they harp on that repeatedly in the majority, and the dissent also, engages on that. Can you walk us through the Eighth Amendment analysis you were urging the court to adopt?
Yeah, so let me to back up first a little from the Eighth Amendment. There's no, I think, exchange with Justice Sotomayor about this during the argument. There's no question, just as a matter of originalism, at the time of the founding era, what Grants Pass was trying to do would have been antithetical to all kind of to founding principles, because we had a settlement system. There were a lot of problems with our settlement systems, but one thing they did better than what Grants Pass is doing is that they required each community to take responsibility for poverty within the community. And there are actually laws, rules from trying to banish impoverished people into other jurisdictions. So there isn't really any question that if you went back to the founding era and said, hey, what do you think about a law that where this one settlement gets to put up the city gates and push all of their homeless people into other jurisdictions, that wouldn't have happened then. And then you see in our Constitution this idea that we all rise and fall together. And you can't put up the city gates. It's woven throughout a number of different provisions. It's in the Privileges and Immunities Clause, even the Dormant Commerce Clause. Justice Sotomayor cited a case, Edwards v. California, that said the Commerce Clause prohibits jurisdictions from pushing poor people out of their communities. Due process, we'll probably talk about that in a minute. But what the court said in a case called Robinson v. California back in the 1960s was that when a jurisdiction attempts to banish an unpopular group of people by criminalizing their status, criminalizing who they are, that violates the Eighth Amendment cruel and unusual punishment clause. And I'll push back a little on kind of the characterization. I think you're right that we typically think about the cruel and unusual punishments clause as addressing kind of really barbaric punishments. And it's right, it was intended to do that, right? So burning people alive or beheading are things we don't do anymore. But going back to the original meaning of the punishments clause, we're going further back into the common law in England and what was going on there, it also addressed excessive punishments. So you had this idea that, imposing the death penalty for writing a bad check, that would be cruel and unusual punishment because it would be so grossly disproportionate to the offense. And so what we have in Robinson v. California is this principle that there are some things a person is or does that are so innocent or so harmless and unavoidable that any sort of punishment is going to be so disproportionately excessive as to violate the punishments clause. And in Robinson, it was a law that criminalized the status of being addicted to drugs. So you can punish using drugs, but to say that because someone is an addict, they are in violation of the law. What the court said was even a day in jail for the crime of having a sickness or having a status would be cruel and unusual punishment. And so that's the case law we were relying on here based on some earlier Ninth Circuit cases. So the Ninth Circuit law had already been pretty developed in this space before this case came along, and we kind of stuck on that lane.
You mentioned the Robinson case that is cited repeatedly. Another case that comes up is called Powell v. Texas. And reading the majority opinion, there's a surprising, at least surprising to me, there's a guest star that makes a frequent appearance that's invoked many times as sort of blessing the outcome of the decision. And what's striking is that in a 34-page opinion, Justice Thurgood Marshall's name is invoked approvingly 19 times. And that's because he's the author of Powell v. Texas, a plurality opinion. And the majority thinks that the result in Grants Pass flows logically from Powell. And I'm curious if you could talk a little bit about that and whether you think the majority is fairly portraying Justice Marshall's position, an icon of civil rights. Do you think Thurgood Marshall would be joining the Gorsuch opinion today, restricting the rights of the homeless, or would he be in dissent?
Yes, so I certainly do not think he would join the majority. And I'll say I was really surprised to see the majority decision because not even the city argued that Powell supported its position. We were saying Powell didn't support their position, and they said Powell didn't support ours. And I think we kind of ended up in agreement that Powell really left open the question here. So that case was about a law that criminalized being intoxicated in public, and the criminal defendant there was an alcoholic who had been found intoxicated in public, and so we ended up, it's not worth kind of going into the way the court was fractured, but you ended up having a plurality decision that was based on a concurrence by Justice White, where he said, well, you do have the choice of being intoxicated at home, that he was not homeless. And so therefore, this doesn't fall under Robinson. Our point was that even putting aside that, compulsive conduct rising from addiction is just fundamentally different than universal biological necessities like sleep, right? Every single human being sleeps. And so the question I think was whether this idea, well, you can't criminalize, I don't know if the court agreed with this, but if we started from the premise that you can't criminalize status, so you couldn't directly say being homeless is a crime, could you say, well, being homeless while sleeping is a crime, being homeless while breathing is a crime? And Justice Kagan focused on this during the argument, and that's essentially what the law did here. And so I think that's very different. Yeah, I had an exchange with, I think, the chief at some point during the argument where he said, why is using drugs not the same thing as saying someone has an addiction? Addiction is defined by the urge to use drugs or the urge to use alcohol. So you couldn't criminalize under Robinson having that urge, but that's different than actually engaging in the compulsive conduct. But then the court decided it was going to, I guess, ultimately what the majority opinion does is equate sleeping with drug use.
So where do you think that leaves the jurisprudence in this area? It's this distinction between conduct and criminalizing status. Where does that sort of leave us?
Um, I mean, I think, yeah, we'll have to see what's left of Robinson after what the court said. Um, uh, uh, to the extent, maybe we talked about this a minute ago. I don't think the court foreclosed other sorts of constitutional challenges here. I think under Robinson and the court's precedent, the Ninth Circuit was correct to locate this particular right in the cruel and unusual punishments clause for the reasons we just discussed. I'll say there's the excessive fines clause is also potentially in play when you're talking about fining homeless people for sleeping in public. That claim wasn't before the court. The city decided not to pursue a challenge to our excessive fines claim. Potentially, you have a due process problem when you are criminalizing kind of universal human needs like sleeping. And as I mentioned before, the Commerce Clause, privileges and immunities. So I don't think, Justice Sotomayor makes this point. I don't think we're entirely out on the idea that there's a constitutional problem here. The court was focused on the Eighth Amendment.
Yeah, just piggybacking off that answer, because yeah, I think the majority opinion does reference that there may be other provisions of either constitutional law or state law that speak to a city's enforcement of an anti-camping ordinance, since the majority is framing this primarily as a camping issue. In the wake of the decision, what other options, and I know there's lots of practitioners on that are curious about this, what sort of practical options do legal aid services providers, other advocates have when encountering overzealous enforcement of these types of laws?
Yeah, so I would say one, if you are doing work in this space, you definitely want to be coordinating with the National Homelessness Law Center. They are, kind of the cornerstone of doing a lot of this work. And I know that they're working with folks across the country on how to deal with the wake of this decision. So I would certainly coordinate with them first to make sure people aren't kind of working at counter purposes. It doesn't really show up in the opinion as much, but Justice Gorsuch, Justice Barrett, and Justice Kavanaugh all asked questions about necessity defenses under state law. So the idea that someone could affirmatively say that they can't be prosecuted or penalized for engaging in unlawful conduct where they had no other choice. So we'll have to see how that plays out. But that's certainly, if we're in a situation where the homeless person is fortunate enough to have counsel, that might be more on the table. The problem is most of the time folks don't have counsel. And so the notion that they're going to be able to go to court and assert affirmative defense is pretty impractical, but that's one option.
Yeah. Just shifting gears a little bit to the dissent, which you've mentioned a couple of times here. There really is a stunning contrast between how the dissent pursues its arguments and how the majority presents its arguments in the framing. And Justice Sotomayor's dissent starts with a very straightforward, simple line. Sleep is a biological necessity, not a crime. And the contrast there that I want to sort of talk about, as we've talked about, the majority opens with a doom and gloom scenario of this public policy problem of encampments. What is a city official to do? And the dissent really zeroes in on the fact that at the center of this problem is a human need. What do you think the dissent gets about this case, both factually and doctrinally, that the majority is missing?
Yeah, this is such a good question. I think Justice Sotomayor does such a beautiful job of one, just being incredibly meticulous about the record and the accuracy of what she's saying and citing to actual portions of the record and not just amicus briefs by the other side. And I'll say, not to be too nitpicky here, you mentioned, earlier, this to me is just emblematic of the majority decision that there is a detailed footnote of all of the amicus briefs that were filed supporting the city, mostly by elected officials and municipalities. We had substantially more amicus briefs on our side, and they weren't from politicians. They were from social scientists and direct service providers from every major faith leaders from every major religion, including the U.S. Conference for Catholic bishops. Ultimately, I think there were 42 amicus briefs filed on our side, representing 1,159 organizations and people who are involved in this work. So I think the majority certainly missed that. But more importantly, I think the majority missed the actual human beings. This is like, it's hard to talk about. And so I would urge people to read Justice Sotomayor's opinion, because I think it makes clear there were so many blockbuster cases at the end of the term. I can't think of another one in recent history where the decision is going to unleash the extent of human suffering that we're going to see as a result. Homelessness is already such a difficult circumstance, and there are actual, real people. Just if I could just like spend a minute talking about some of the real people in Grants Pass. Carolyn Hill is one of the class members. She tried to go to that religious transitional housing program. It was full, and then another time they wouldn't let her bring her nebulizer with her. She's disabled and can't work. So she was ticketed, fined for sleeping outside. She was given a trespass order saying she couldn't be anywhere on public property. And when she tried to sneak back in to get her nebulizer, she was arrested and sentenced to 3 days in jail because she was there looking for her nebulizer. I think one of the distortions you see in Justice Gorsuch's opinion is this idea that the city was taking a light touch. They cite a couple of policy things that the city put out suggesting that they were not actually interested in criminalizing homelessness. There's overwhelming evidence that that's false. The district court rejected that, and it's the initial fact finder. But one of the things that says, well, we didn't have any named plaintiffs who had actually been fined and jailed for sleeping outside. The opinion is careful in its wording because one of our class members, Deborah Blake, or named plaintiffs had exactly that experience. She had lost her job when she was 50 years old. She couldn't afford rent. She was disabled, and she was fined many times, given trespass orders, and she tried to go out to the place in the wilderness that she was supposed to go to, but she was disabled and couldn't really get there safely. She's not a named plaintiff now because she died. She died with over $5,000 in fines. So when the majority opinion says we don't have a named plaintiff who's experienced that, it's because she died while the case was on appeal, and the district court or the Ninth Circuit had remanded for us to add another plaintiff, and there are many, many that we could add. And then, the other two named plaintiffs were fortunate enough to have cars, so they would sleep in their vehicles, but that is also unlawful camping in Grants Pass. And so the police would go to anyone they found sleeping in their vehicle and told them they had to leave or fine them. So they were both able to go out of the city and sleep at night in their cars, kind of out in, past city lines. And that's why they hadn't actually been convicted. It didn't change the fact that the point of the law was actually kind of being effectuated right there. They were being banished into other jurisdictions. So I'll stop there. I hope. I think it's one of those decisions that will be kind of, it's a rip in our moral fabric, right? And I think what's most concerning about it is what Grants Pass did is really extreme right now. It is kind of an affront to our social norms and our moral norms. Most jurisdictions have not done that, but the norms change over time. And when the United States Supreme Court says totally fine for you to do that, we could be moving in a direction where states, right? We've seen states like Florida and Kentucky will say, oh, great, let's make it a crime to be homeless within the state of Florida and push everyone into Georgia. And then what does Georgia do? It does the same thing. And I don't know where we go from here. And I'm deeply concerned that what was cruel and unusual in terms of treatment towards homeless people will become the norm. Still cruel, but also a normal way of thinking about homelessness. I hope that's not what happens. I hope we look back in 50 years and we see this decision the way we now see Korematsu or Plessy, but we'll have to see.
Thank you for that. And I think it is so important to center the human beings at the center of this, your clients, whose rights have really been stepped on, in my opinion, by this decision. One question that's come up in the chat, and I think will be relevant to a lot of folks calling in: how do you think pro bono lawyers can get involved in future legal advocacy and support of our unhoused neighbors?
Yeah, this is a great question because one of the things that the court's decision makes more difficult is this kind of class-wide injunctive relief. The city decided that it wasn't going to challenge kind of that posture of the case, but if we're relying on kind of the necessity defense in state law, individual homeless people are going to need lawyers who can go to court with them when they're fined, when they're criminally prosecuted, and say, my client had nowhere else to go. So I hope that, organizations doing direct legal services will be able to, I know funds are limited. And so maybe this is where pro bono lawyers come in, right? Volunteering, working with the legal aid lawyers and public defenders to ensure that folks are able to raise these defenses.
And another question, this is less about the case and more about you, I suppose. I'm sure there are a lot of young lawyers on the line who have aspirations of arguing the Supreme Court or working on Supreme Court cases. What's it like to appear before this court? And how do you prepare for a SCOTUS argument?
Yeah, so I have done Supreme Court appellate work for my whole career. It's now close to 20 years. Um, I moved into this role, I think, Ryan, you said in early 2021, and I moved into this public interest space. I was really prompted by Justice Ginsburg's death, and wanting to be in a role where I could really focus on Supreme Court from a public interest perspective and not counting arguments or not kind of the business development pieces, not thinking about the prestige of the Supreme Court, but really focused on the public good. And so my work is incredibly narrow. I spend all of my time just trying to think of how to get 5 votes or how to keep away 4 votes when we're opposing a cert petition, which is a lot of what I do. It turned out this year I had 2 merits cases. I'd prefer just to have a bunch of successes in getting cert denied, but that was not this term. So it's an enormous amount of, we write the briefs, right? So we're steeped in the law. I think I did 3 moot courts with other Supreme Court advocates, just drilling and kind of getting me ready for the argument. I had the homeless advocacy community really involved in kind of listening and pushing back when they thought I was conceding things I shouldn't concede. And the actual day, there's a lot of doom, I think, leading up to the argument, just because of amount of responsibility. I really felt the fear that I wouldn't get the right answer, and a lot of people would suffer was heavy on my shoulders. Luckily, on actual argument day, mine clears. Like, it's almost like a primal, I've got to be here, I've got to deal with the situation. So argument day is much better than the time leading up to it. And it's hard. It's hard when to lose something like this, right? I think we did the best we could. I think we made all of the arguments that were available to us, and it just wasn't to be with this court. And I'm really sad about how that's going to impact a lot of people.
How was this news received back in Grants Pass, the decision itself?
I was on listening to a Zoom last week. Helen Cruz is a resident of Grants Pass who was previously homeless. I think she now is housing through a church. And she was out here for the argument and then went back to her community. She said people are really scared. Right now, the injunction is still in place because of our excessive fines claim. I think someone asked about that. I don't think that issue actually can go back to SCOTUS because the city waived. That was one thing that came up during argument and would have been a really good reason for the court not to take the punishment clause piece of it. So I think things will be okay, at least in the short term in Grants Pass. But obviously the decision has implications across the country. I do want to answer this first. Someone has a very detailed record question.
Sure.
I think someone who
Go
knows
for
the
it.
case well. And I would, so this is a good question. When I initially was describing what the city did, I was very careful to say that it had decided in 2013 to more aggressively enforce the law. I didn't say that they enacted the law, and that's because the ordinances were actually in effect, had been passed earlier. So the record does not say what year it was. This attendee suggests it was 2009 or 1998. So no, there isn't anything in the record about kind of the origins of the law. I don't think either side suggested otherwise. We do know at that 2013 meeting the city council president and the other folks who were there decided that they were going to rely on those ordinances to target the homeless population and make it uncomfortable for them to leave. And you actually have depositions in the record from the police officers saying that they were only enforcing the laws against homeless people and that they would not enforce it against a stargazer or a baby sleeping in a stroller, right there, a person who wasn't homeless. Justice Sotomayor talks about that evidence in her dissent.
Right. And another question in the chat, once these individuals are incarcerated, what's the plan? And I know from my own background, coming out of my work at Civil Rights Corps, that the knee-jerk reaction in a lot of circumstances is to incarcerate for all manner of crimes without any plan about what's going to happen on the other side of that. But I'm curious, Kelsey, about if you have a take on that, having worked on this case. You have people who are homeless and are faced with incarceration essentially for being homeless. What happens on the other side of that in terms of their housing prospects, their employment prospects, all that?
Yeah, it's a really important question because if we want to talk about policy, right? Like the idea that criminalizing sleeping outside when someone has no place to go, somehow it can't have a deterrent effect because the person actually has nowhere else to go. So the only thing it can possibly be accomplishing is either pushing homeless residents into other jurisdictions or they end up incarcerated. Well, what happens when someone's incarcerated? They now have a criminal record, or even if it's just fines, they now have debt that they can't pay, which is going to make them ineligible for housing. It's going to make them ineligible for a lot of employment. And a good number of homeless people have jobs. They just don't make enough at their jobs to pay rent. That was true of John Logan, one of our named class members. So you put someone in jail for a couple of days, they don't show up at their job. Now they've lost their job. So there's no possible argument that this sort of statutory scheme is designed to mitigate the homeless problem in any way. It's just entrenching homelessness for people who are already struggling to kind of pull themselves up. Now they really can't.
And one other doctrinal question that's emerged in the chat, and this is about the Eighth Amendment doctrine. The question is, does this case mean that the evolving standards of decency approach is gone? Is Martin effectively overturned? How does this affect Oregon state law prohibiting criminalization of homelessness?
Okay, so that was a lot of questions. Wait, so let's start with the first one. So it does overrule Martin. Martin's gone. Martin was the first Ninth Circuit case that said it violates cruel and unusual punishment to criminalize homelessness. What was the evolving standards of decency? So the court didn't end up addressing that. And we actually didn't rely on evolving standards of decency. So just for folks who aren't familiar with Eighth Amendment jurisprudence, going back over 100 years, the Supreme Court has recognized that embedded in the term cruel and unusual punishment is the idea that we would be looking at modern social norms as opposed to being kind of frozen in time to what was considered cruel and unusual at the time of the founding. And that's actually a textual approach to the cruel and unusual punishment clause. It's kind of sui generis in that sense, right? That baked into the text is the notion that it would be evolving over time. I don't think the court really addresses that. We didn't make that argument because we were actually able to show that at the time of the founding, this would have been considered antithetical to social norms. So we emphasize that. We did also have a whole section on our brief showing the ways in which what Grants Pass was doing was really extreme and not done by the vast majority of jurisdictions.
One question I had about something that you said earlier, Kelsey, and it was about the amicus briefs. As someone who submits amicus briefs and signs off on amicus briefs on behalf of the Washington Lawyers Committee, in this case also, we submitted an amicus brief or signed on to one. What do you think the role of amicus briefs is in Supreme Court decision making? Now, how impactful are they? Does it matter where they're coming from? How do the justices sort of weigh those arguments as they're considering the merits briefs and how a case should come out?
Yeah, it's a great question. And it was frustrating. So I think, folks who've done Supreme Court work know that when you're at the cert stage, so when a cert petition is filed with the Supreme Court asking the court to review, the cert petition may have amicus brief supporting it, but you would never have amicus brief supporting the opposition brief. So, and that's because the whole idea when you get to the Supreme Court is that the case, what you're arguing is the case isn't significant. So if you had amicus briefs on both sides, it would counter that purpose. So at the cert stage, there were 25 amicus briefs supporting the city, and none on our side, very intentionally. And so once the court granted the case, I think they ended up with 34 on their side. Interestingly, they had Governor Newsom and some other kind of in the city of San Francisco supported the city in getting review, but you actually their merits briefs once the court took it for both the governor, city of San Francisco, city of LA, California Solicitor General, all said in their amicus briefs that they didn't think what Grants Pass was doing was constitutional. They didn't like the kind of the law more generally, but even they weren't as willing to go as far as Grants Pass did. So I think here it was incredibly important because it was the people with the expertise, right? Social scientists who have been working on homelessness policy for decades, putting actual empirical evidence on how this sort of criminalization of poverty entrenches homelessness instead of solving it. I thought it was really important, in a cruel and unusual punishment clause that we had so many different kind of diverse religious perspectives all coming in and saying this goes against every tenet of our faith. It's an affront to our social norms. It's cruel by any standard. And then the socials, it was, I think, incredibly valuable for creating a record. We can't always get 5 votes just with the current composition of the court. We can make sure that we've told the truth and we've created a public record of it for future generations. And so I think those briefs were really important for that. And Justice Sotomayor did an incredible job of kind of putting that record into her dissent. You see her relying on those briefs pretty extensively. So I'm glad we had them, and I'm glad we were able to kind of all together kind of comprehensively tell that truth.
Right. So we're at about time. So I wanted to thank you, Kelsey, for having this conversation with me and answering the questions. I am curious for one last question, what you think the implications are for governments that are going to now go forth, read this opinion, and have to decide how to enforce their own laws dealing with the homelessness issue.
Yeah, I hope, there's this line in the majority opinion that says, oh, cities don't have to criminalize homelessness, they can choose to. And that's some comfort to all of us. But it is true. So I do hope that most jurisdictions will realize that what Grants Pass is trying to do, how counterproductive it is to addressing the homelessness problem. And because once it starts to fall, right, it's a domino effect. If one city does it, then the one next door has to do it, and we end up in a really dystopian place, even more dystopian where we are now. So I hope cities will think carefully. There are proven solutions to homelessness, and that's in our amicus briefs as well. There are cities that are doing a really good job at this. There are numerous amicus briefs about it, and it really comes down to housing. If we don't have enough housing for people, they're going to end up on the streets, and that's a concrete thing we can do if we're willing to be committed to it.
Great. Thank you all. We'll leave it there for today, and I want to thank Kelsey again, and thank all of our attendees for coming out. And everybody, have a good afternoon.